Welcome to Power Up Your Practice, the go-to podcast for law firm owners and managing attorneys working on the business, not in it. I'm Ruby Powers, your guide into the heart of law practice management, bringing you insights from leading legal minds, trailblazing attorneys, and expert guests who provide you with an actionable perspective on running your firm more effectively and efficiently. Prepare to open your mind, be inspired, and power up your practice to the next level. Hey everyone, this is Ruby Powers. I'm your host of Power Up Your Practice, and today I've got Craig Dobson, who's a friend. He's an immigration attorney. He's also a legal ethics advisor to lawyers, and he helps lawyers deal with ethical matters and so how they can live in peace and ease. And I'm really excited to have him. He represents lawyers in New York, Georgia, and before the Executive Office of Immigration Review and USCIS. He helps lawyers optimize their offices to practice ethically and avoid disciplinary complaints and with the ethics matters so they can live in peace and ease, which definitely sounds like we all need to have. So, Craig, thanks so much for joining us. Tell us a little bit about yourself.
Yeah, thanks for having me. So I've been an immigration lawyer since 2005, and then around 2016, a friend asked me to take on their ethics case. And I had a friend who's a famous kind of ethics scholar, professor, asked him to help me do the case. So I did it, and I found that I liked it more than practicing immigration law. And then I've been doing that kind of stuff ever since.
Well, it's an interesting journey from your transitioning or sort of diving into another field within law. So what are some of the trends that you're seeing or common misconceptions or things lawyers need to know on how to be on the up and up in their ethics?
Gosh, so many things. What I've seen recently, within the field of immigration law, I've seen people who take on too many cases. So it's interesting to me to see lawyers' offices behind the scenes. I see people who practice for a great many years and they don't make a lot of money. And then I've seen other people who practice for a very short time and they have what would really be an unbelievable amount of work for some of my other lawyers. They just really couldn't believe it. If I were to tell them, without showing them, they just wouldn't believe how much work some of the other lawyers have. So I have people who have ethics issues arise because they can't quite figure out how to manage the massive amount of work that comes through their door. So that has to do with supervision, proper use of technology, maybe outsourcing, those kinds of things. And the good news is if you have a lot of volume, you can at least afford to pay somebody like me. So the challenge that we run into on the other end of the spectrum is someone, maybe doesn't make a lot of money, but then the challenge is they can't hire advisors, business advisors like you or ethics advisors like me to help them make the changes they need to. And I'm not sure what the magic sauce is for those people who bring in the huge number of cases, whether it's a personality issue, a kind of aggression, or maybe just some good luck mixed in. But it's interesting to observe that through time.
So that reminder of just don't take on more cases than you can handle. But if you do, make sure you have the infrastructure and the team to help support you in that. And it's funny because I just got off a law practice management consulting call where we were talking about how to get the phone to ring and how to get more clients. And we're talking about like what happens if you get so many clients and you don't have, but that's true. Like you need to have the infrastructure to handle, but sometimes it's like you're building the plane and taking off at the same time. So you're like, I'll deal with that when that is a problem. I'm having too many clients. So that's one trend or theme you're seeing. And a lot of our audience are practice managing attorneys, right-hand associates and partners, and so of all fields of law. So what are some of the other trends that you were mentioning something about a delay in notifying the malpractice insurance carrier? What are you seeing there?
Yeah. So it's usually during the first consultation. If someone calls me and they already have a problem,
Mhm.
somewhere during the consultation, usually we have to talk about a malpractice carrier. So let's say it's an ethics issue. I think it wasn't always the case, but now the malpractice carriers often have ethics coverage too. So whether it's an ethics issue or it's a malpractice issue, a question comes up during that initial consult. Do I need to notify my carrier? And most people don't want to do that. What they're really afraid of is that the prices that they already can't afford to pay are going to go even higher.
Mhm.
Um, but the problem is, well, first of all, a lot of times your premium doesn't necessarily increase because you've made a report. Sometimes it might.
Mhm.
But the other thing is, if you don't report, then the problem can become you could invalidate the
Mhm.
policy for that one specific issue. There could even be issues where you might invalidate the whole policy. Or I saw my friend is actually the same ethics scholar who helped me with my first ethics case. He had written an article where the leader of the law firm reported honestly that she didn't have any claims, but there were subordinate lawyers who were aware of issues. And
Mhm.
so, I guess the moral of the story is before you renew your malpractice policy, you should send around a memo where all the lawyers sign off on it that says they're not aware of anything that could give rise to a claim. Because what happened
Mhm.
is I think it was a serious invalidation of coverage in one of the states. I can't remember if it was Minnesota or Wisconsin. Seems like it was one of those two. Um, but it was a big invalidation of the policy where uh, the senior lawyer wasn't aware that there was an issue out there. So that can be an important thing. But usually I say if you're in doubt, go ahead and make a report. You can always call and talk to somebody like me. Really, the first step is just read what the policy says. But I've definitely seen instances where the insurance carrier comes back and they issue some long detailed letter saying, you know, this is what we're going to cover, this is what we're not going to cover, or we'll do you this favor this one time, but we're never going to do it again because you should have told us way back. And one way to think of it logically is if you have a problem, the carrier often wants to know about it. So they have a financial interest in telling you, trying to help you deal with it, right? So if you have a problem and you're fumbling around trying to figure it out on your own, then that could lead to greater problems for you and for the carrier. And I guess it goes along with a broader theme, which is if you have a problem, try to face it. So sometimes what we see is an issue arises, and then the lawyer wants to minimize it. So
Mhm.
sometimes we see a lawyer being way too hard on him or herself, and then other times we see a lawyer who minimizes the problem and thinks, "Oh, no big deal. I'll just fix it real quick." But then that quick fix doesn't work, and then they try another maneuver that still doesn't work. So sometimes it can be nice to have somebody like me who can try to give you objective advice because sometimes lots of lawyers who call me are way too hard on themselves. They think they've done something horrific when really not that big a deal. Then on the other hand, there are people who think something's not a big deal, and maybe it's because they have a block. Um, they just can't face the reality of what's going on. But in virtually every case, it's good to face it so you can deal with it because a lot of these things are problems that can be solved.
Yeah, I think one of the things that happens when there's an issue like this that you don't know who to call or what to do, even though we were being trained and took ethics, professional responsibility, and we, have to keep up all that in our CLEs and what have you, is like sometimes fear can take over, and it's like, it is sort of an attorney trait to not want to admit fault. And then, and then to think that like you might get in trouble for something and then you don't know who to talk, like they don't know who to disclose what to because they don't know if it's going to come back to them in a bad way. And so I think it's good to do all the preventative measures, and to be always staying up on this, but then it's I mean, I get it when people get a little overwhelmed, and that's why it's good to have someone like you, on call, or to have those resources like, the State Bar of Texas. They have a hotline. They might not call you back the same day, but they're generally responsive. But again, it's good to have those resources. And I think the other thing that to note is that it's not just like you mentioned, the attorneys and the staff. Like it's not just you, the principal attorney, but like you have to constantly be training your entire team and
Yep.
making sure that they're they know what the rules are, and they're staying ethical, because it's like our duty to keep the rest of the firm running smoothly and follow those procedures. Recently, what was it? Okay, I was on the ABA Tech Show planning meeting, and we had this whole session about what's a CLE and how to get CLE credit, because we were being taught by the ABA about this, and it was really fascinating. And one of the things I thought about was how law practice management, not always do you get CLE credit for it, because apparently they didn't think it was important for lawyers, like historically. But isn't law practice management like one of the key points that like usually gets, if you're not strong in that space, what gets you into trouble? Because it's like the common things they always tell us is like not responding to the client, not being communicative, whatever. What are some of the things, other trends that you see in like best practices to avoid them?
Yeah, gosh. I mean, there's so many things with practice management that have to do with ethics. I mean, there's too many to list, but one example would be, you just said constant training, right? So you have to have constant. So there are lots of lawyers who think that they're too busy to engage in training. We're probably too busy to engage in training, too busy to have staff. So because you have to do that. In the long run, it pays off. So another example would be, so my wife used to work in operations. So she would call these books that they would use playbooks, right? It could be called an operations manual or whatever. Mm-hmm. So I think all lawyers should have one of these. And then it's not something you have to draft. You don't have to draft 1,000 pages overnight. I mean, it can be a work in progress. But that's a practice management tool that can actually add tremendous value to your firm. Especially a firm like an immigration firm, because you get down to the minute details. Like, this is exactly how I want you to prepare a package. This is how I want you to send a FedEx. If you deviate from this, you need to get supervisor approval or whatever it is, but just step by step. And you don't have to draft this thing. A lot of times your staff who are already doing these things can draft it, and then they can submit it to you for your approval. But you can build a format, kind of formalize it. But what does that satisfy on the ethics side? Well, the ethics side, we have rules 5.1, 5.3, and they talk about supervising non-lawyer staff and supervising lawyers. So one of the ways, let's say one of your staff makes a mistake, you're not responsible. I heard one of my friends wrote an article once that said something like, your staff holds your license in their hands, or something like that. It's not exactly true. If your staff makes a mistake and you come to me, say you're accused of something, you come to me, the first thing I'm going to look at is, did you honor your obligations as a supervisor? And did you fix the situation when you notice there's a problem? So one of the things I could use is one of these written playbooks that says, this is exactly how the person was supposed to do this. They were responsible for this, for doing it exactly this way. They deviated from it, but you told them to do it the right way. So you actually have this supervisory structure in writing. It's not to say that's the only thing. You can't have some document buried away that well someone's not going to read, but it can really help. It can help a great deal, especially if that person actually participated in the drafting of this thing. And then you could update it, say every 6 months or every year. Then imagine, you start making a lot of money, you want to sell your firm. Well, along with that would be this operations manual that would tell you how to do every little thing. Or then let's say the lawyer goes on maternity leave, who does one certain kind of work. Well, then you've got their operations manual, and you see, or they get sick, right? Then you know how they do whatever it is they do. You as the supervisor might not know exactly. So that's another reason. So it's just one example of where there's a huge intersection with practice management ethics. Also, just generally, well-being issues are a big deal. So we found one well-being issue is sometimes in bigger firms, the intake staff constantly hear the problems, but they never get to participate in the solving of the problems. Oh. And so what they're finding, there's some people who are saying that those people may suffer worse than anyone else in the firm, because they only get to hear the bad stuff. They never get to see the other side of things. So so there's a well-being issue that's related to the practice management issue. And then just generally keeping people happy within the firm. You want someone to feel safe enough to tell you when they made a mistake.
Yep.
So, and also I want lawyers to feel safe enough to come and tell me when they've made a mistake. So some people speak to me and they say, oh, I'm so embarrassed. and they say, I reached out to another lawyer, maybe not an ethics lawyer, and they were so mean to me. They were so harsh.
Hmm.
And so I felt so judged that I didn't want to get further help. But we have to realize, when we're asking and also when we're helping our colleagues, if we're really harsh in our response, we don't encourage somebody to get better, right? We just encourage them to hide whatever the problem is and keep making the same mistakes over and over again.
Wow. It's all connected. I hadn't even thought
Yeah.
about like the intake or receptionist. I mean, I have seen that in when you have a lot. I've seen it with the legal assistants if they do a lot of the same type of cases like asylum worker, immigration court, or whatever. That it can there can almost be a life cycle for that. Just like the asylum officers seem to have like a 2-year life cycle in some respects, just because it's a lot on you. One thing we do at the firm is we try to do a lot of happy stories of the wins in our office
Yeah.
meetings, so that we can share. And I like to tell a little story about it, like how we got there, because it wasn't just we filled out a form, or like it usually like there was some obstacle, and then we worked together. And I think a lot of times the reception and intake and a lot of the admin don't get a lot of the credit they're due, because they do help run the show. And it's probably sort of like the people dishwashing and busting and stuff in the restaurant. They're sort of unseen, but they help get the job done. And that's a really good point. Yeah, and to your point about like the value of the firm, that's another interest of mine, is helping attorneys prepare for a sale. Is that the more, yeah, you're right, operations manuals and systems you have in place, the more it can be, any other firm owner could take over. If this is, if it's not just dependent on one person knowing everything, but like everyone can just sort of plug in, because you have the operating systems in place. And that's really, every time there's like a issue in our firm, I always question, was there not enough clarity in our training, or is this a glitch in our operations, or did someone just make a mistake,
Yeah.
and then we try to like figure that out. Like that's my approach. But I also agree with you, like you need to create a culture where people feel comfortable to address issues and not be like trying to sweep it under the rug, because then you'll get more problems. And a small problem can turn into a big problem pretty fast, right?
Yeah, and I like one thing you said with the talking about the win. So really, you might that might be something within the field of positive psychology, where in positive psychology, sometimes people think of it as only paying attention to the good stuff, but it's not really the case. It's just making sure, just like I mentioned earlier, you don't ignore the bad stuff. You also have to make sure you pay attention to the good stuff, and it's a great example when you talk about. There's a what went well exercise in positive psychology, where you, at the end of the day, you write down 3 things that went well and why. So really, when you talk about your wins, you said like you have a challenge and then you say how you overcame it. And that's kind of the why behind it. And I think with that what went well exercise, I think there was a study that if you do that every day for like 2 weeks, it can have an impact on depression 6 months down the line. So you're really doing that at the office level. And I think that that's part of paying attention and not ignoring anything, good, bad, and stuff kind of in the middle that's boring.
It sort of reminds me of the benefit of like gratitude journaling as well. Like what they say, if
Yeah.
you write out what you're grateful for on a regular basis, it can change your mindset. I love how we're merging all this thing from like wellness, which I know is a big strength of yours, and ethics and law practice management, and like, and dabbling a little bit immigration in there too, even though I think our conversation benefits even those not in immigration space. What are some of what are, from all your research and reading and just practice in ethics, what are some of the areas that get attorneys into the most trouble?
Well, failure to communicate, that's a big one, but it's practice management related, right? How do you, so one way to look at this might be, especially with lawyers who charge flat fees, is,
Mm,
there's so much discussion around worrying about charging people too much. But something that I talk about sometimes now is making sure you charge the client enough to do a case properly. So if you don't build into your pricing, being able to respond to some phone calls when the client calls, you're not charging enough because you have a duty to keep the client reasonably informed. If they call 50 times in a day, you don't have to answer all 50 calls, but you have to keep them reasonably informed. Part of that can mean letting the client know when a mistake is made, not even necessarily a material mistake. There's an opinion out that says, like, let's say you and I are co-counsel and you notice I make a mistake, and maybe it's not even material, but if it's significant enough that the client might want to fire us because of the mistake that I made, then your job would be to come to me and say, hey, Craig, you need to go ahead and tell the client this. And if I don't, then you should, right? So, but that's part of the communication to the client. But just so that's a big one, keeping the client informed of the good and the bad and the boring. And then, so that's a big one. I guess that one comes up, gosh. And, there's competence issues that can be overwhelming. We both practice immigration law, right? So it's an ultra complex, really unappreciated area. So some people say second, maybe only to tax law in complexity. So trying to figure out, trying to self-assess. One thing that fascinates me about law is we often self-assess our competency. So let's say you're like a heart surgeon, you would go through a long residency, right? You'd have people critique you. I guess if you're bad enough at it, somebody, you'd eventually get thrown out of a residency program maybe. But in law, it's different. You, to a great extent, maybe to too much of an extent, you get to self-assess your competency. So how do you know when you're competent? And I can remember, reading about immigration law when I had first started, and I would think I had something figured out, and then there would be something, what I call lurking in some other place that I wouldn't be aware of. So it showed me the importance of reading something like a comprehensive treatise or book on the subject, because I might think I know everything reading this section, and then, there's something lurking in another area. So competence is a big one. Diligence. So diligence can matter. And one challenge with diligence is, can you become competent quickly enough in order to be diligent? So let's say you take on a matter, you're not quite sure how to do it, but you're going to figure out how to do it. So it's your first time. Let's say you've never done a huge, $1 million investor immigration visa. It's your first one, but you're experienced in immigration law. So the question would be, can you get up to speed quickly enough so that you don't fall below the diligence standards? So sometimes a lawyer will take on a case and they take way too long figuring out how to do it. So then that causes them to go below the minimum standards. And as you mentioned too, sometimes lawyers just plain old, just make mistakes. So it just happens. They make a mistake because they're a human being. Some disciplinary authorities take that into account. Some disciplinary rules take that into account. So in New York, one of the foundational duties that you owe to a client is competency. Whereas in New York, our rule says a lawyer should be competent, not a lawyer shall be competent, but a lawyer should be competent. And it really takes into account the fact that you could have an immigration lawyer like you, who's at the top of the field, and then you could still make a mistake simply because you're a human being. So the New York rule takes that into account, whereas the ABA rule, for example, says you shall be competent. So so competence is a major thing. There's always the trust accounting stuff, lawyers having to do a little bit of banking, and that can make life difficult depending on what state you're in.
And I know, okay, I've got a couple that I'm thinking about. When some of my court cases that were on flat fee at the time started dragging out for really long, it made me, and also just in general, I think it opened up my eyes to how the contracts I had made were no longer reasonable because I didn't anticipate that the case was going to take so long. And so I had to reevaluate how much work was needed and what was going to happen, talk to the client, write a new contract. And it felt very uncomfortable, but I know that you're allowed to do that because if you find out that the work needed is more than was originally in the scope, and that can happen. I don't know what other areas, but you probably do. But in immigration, for example, affirmative asylums, we didn't know in 2015 that they would still be a pledge 9 years later. I wouldn't have an interview. or immigration court. Like I've gotten some cases that are over 12 years old right now, So I guess just in general, the concept of having to reevaluate the contract and what are some of the things to consider if attorney has to do that?
Yeah, so I wrote a paper on that. It's called How to Change Fees Midstream, something like that. And it was interesting. I was on the ethics committee. Maybe I was chair of the committee for the Immigration Lawyers Association. We'd assigned it to one person, and then I think they felt kind of like you. They were uncomfortable with the whole subject, didn't want to write it. So I decided to take it on. And it gets to be fairly complicated. So there was this Washington, D.C. case where a guy took on a DUI case, and he quoted a certain fee. And he was pretty doggone sure the case wasn't going to go to trial. Not only go to trial, but it went to a trial that lasted like a few weeks, I think, a couple weeks to a few weeks. I don't know, but it lasted way longer than he thought. And so he told the client, hey, I'm going to raise your fee dramatically. And the client said no, and he raised the fee anyway. So he was disciplined for that. But it was because it was, it's reasonably foreseeable, right? You're a criminal defense lawyer. You might have to go to trial, right? Uh-huh. And so the guy had, needed to anticipate that. In your case, where, you're a highly experienced lawyer and these highly unusual things come out of nowhere, I use those as examples, the asylum stuff, where if it's truly, unforeseeable, then it's different. The rule that comes into play is Rule 1.8A. So that's a rule that talks about business dealings with your clients. So one interesting thing is 1.8A says this doesn't have to do with the initial engagement letter with your client. So technically there's a conflict between you and your client when you negotiate the engagement letter. But if the conflicts rules applied to that, it would be so impractical that you couldn't practice, right? But, you want to make more money, client wants to pay less money, right? In a lot of cases. So, but the question is, what about when you change fees midstream? Does 1.8A apply? I found one state where it does, and I think might have been Idaho. I can't remember off the top of my head, but I think it was one state where in the comments it said it applies to midstream fee changes. So there's actually a conflict, and you have to deal with the conflicts rules. But I only found one state in all the states where I dealt with that. But the basics of it are, if something truly unforeseen comes up, then maybe you can go to the client. Most of the time, it's an asking, not a telling. But then if you do flat fees, what it should be though, you should say in your engagement letter, we reserve the right to change this fee due to unforeseen developments or changes in immigration law or policy or something like that. So at least having that one little sentence in there that should be very, very rarely used, but like in a situation you had, that sentence could help support having to change fees. But the reason we were asked to write the article is lawyers, after one of the big political changes, lawyers were facing bankruptcy because they had quoted fees at one rate.
Yeah.
And then they just could, if you only have 3 cases of a kind, no big deal. But if you have hundreds or thousands of cases at a certain price, you offered those fees in good faith, you need to be able to change them sometimes.
No, I agree. Like it wasn't something that I had really experienced before, but I remember talking to Charity. I think I knew about your article, but even though I forgot, but I think and just that's a good thing to note because of what you said. Like some people might feel like they're indebted to locked in for forever on that agreement that doesn't make sense, and no one could have foreseen what was going to happen. Another common thing I'm thinking about is like when you need to withdraw from, let's say, a court case, for example. And I know that like sometimes it could be a matter of lack of payment by a client, or it could be just a breakdown in the communication. So what are some of the best practices when you need to withdraw from things that might have more like court or things that have a tight deadline and more rules around that of representation?
Yeah, so that can be tricky. So that's something that's come up in my office recently in a couple of 3 cases, and I find some of the really successful lawyers sometimes come to me when they need to withdraw from a case because they know that a problem might arise from withdrawing. So you're kind of put in this situation where if you stay on the case, you might have a problem. But if you withdraw, you're going to take a client maybe who's already uncooperative or angry, and it makes them even angrier, at least temporarily. So you have to look at the rule 1.16 is usually the rule that says the requirements to withdraw. There usually the rule is it's written disjunctively. So each one of them, all you have to have is one of those reasons that's listed in rule 1.16, and then you can withdraw. One of them is if there's no material harm to the client. So that's usually the top one listed. So that doesn't mean no harm to the client whatsoever. So that's an important thing to keep in mind. What it means is no legal harm to the client's case. So it doesn't mean, if you withdraw from the case, almost every time there's going to be some harm, right? It's going to be aggravation, it's going to be inconvenience. But that material harm really gets down to what you were talking about. What about when there's a deadline coming? So one thing is you have to try to withdraw from a case before you get too tight on a deadline. So here in New York, for example, there's an ethics prosecutor. She's not stuck on this. There's no case law that supports it. But what sets off a red flag with her is, or at least a yellow flag is, if you withdraw from a case within 30 days of a deadline, then she starts to, she's paying attention, right? Oh, you withdrew from this within 30 days? You could have withdrawn before that, right? Yeah. So at least under that no material harm standard, that can be tough. But then there are other possibilities where you can withdraw from the client's case even when it causes harm, but you have to do so in the minimally harmful way possible. So even when you've got a really good reason to withdraw, you still got to minimize the damage to the client. So that's why it's good sometimes to have somebody like me, because you may be angry. You may be saying, hey, I don't care about this person. Maybe the reason you want to withdraw is they were doing something shady in the first place, but you still have to protect them as much as you can. There are little tricks that we use, some not really tricks, but pointers we have, like when you send a disengagement letter, even if you send it via email. One of my colleagues gave me this idea: send it as an attached PDF letter. And his hypothesis is, if you send a letter with the attached PDF, it causes the client to pause just a little bit more than they would if they were simply reading an email. So client reads an email, they're mad at you, they respond frantically and say a bunch of terrible stuff. Whereas if they see an attached PDF letter, they read it, they think, oh, they took the time to write me a letter, they signed it, then they scanned it in or whatever. And that alone may cause them to pause a little bit. So it's an interesting thing when we speak to clients, because we sometimes a client with a withdrawal letter that can actually prompt a client to file a disciplinary complaint. On the other hand, I've actually seen disciplinary authorities come back to my client and say, we're sympathetic to you. You had a terrible client. Why didn't you withdraw from the case earlier? And I've even had clients of mine say, I know this particular judge, and they would not have granted a motion to withdraw. But still, the disciplinary authority said you should have filed a motion to withdraw was warranted. At least you had solid ground to file one. So we would like to have seen where you at least tried to withdraw from the case. Because if the client's as terrible as you say they are, you should have at least tried. So then remember, so with deadlines, be careful around deadlines. Probably need to consult with somebody. The tighter you get, try to think of that ahead of time, though, so you don't get into the deadline circumstance. But the other thing is, remember, when you ask to withdraw from a case, you're still on the case until the judge says you're off the case. So sometimes what we see is there could be, and this happens sometimes with really experienced lawyers. Maybe a really experienced lawyer knows the judge. They file a motion to withdraw, and they assume 100% likelihood the judge is going to grant the motion. But then the judge doesn't. They're still on the hook until the judge says they're not. Even if the client's done something terrible, you're still on until the judge says no more. You're on, even if you have to work for free.
That is like mind-boggling to me in some respects. Like we become like an indentured servant. Like especially if like they're not paying or there's some conflict or something. Like I've heard stories. It's never happened to me yet. Knock on wood, hopefully it never does. But I've heard people tell me stories about that happened to them, and I'm just like, but anyway, you're right. Like you want to be ahead of the game. You want to know your deadlines. You want to, if you see a problem, you want to address it. I think that's one of the things where people get into trouble is if they let fear be a paralysis, or they try to avoid a problem and not be preventative of issues. And just the whole having good law practice management and systems and knowing what you're supposed to do at your duty, that all just helps you prevent a lot of issues down the road. And you're, as a leader in your firm, have to be training your entire team and keeping them up to date.
Yeah. I think that's right.
Yeah. Well, I guess that wasn't a question. I was just like a summary. But well, wow. Sometimes people get a little intimidated by this topic, but I just think that there's so much to discuss. And what would you say, maybe before we close up, would you say in terms of AI and technology, what do law firm owners and managing attorneys need to know on that topic?
Well, we're often talking about whether you can use it and that kind of thing, but I think maybe the side that's not talked about as much is, if you don't use it, there's going to
Mhm.
become a time, maybe it's even now, where if you don't
Yeah.
use it, you're not competent. So you have to make sure, confidentiality. So I mentioned competence a lot. So competence is one of the fundamental duties a lawyer owes to a client. Loyalty is another one. And then so it's confidentiality, competence, and uh, and loyalty. So with confidentiality, sometimes that can be with AI, it can be some kind of tension with your competence, right? So AI might help you be competent, but then you might accidentally share information. So there's software out there that doesn't, that protects the data that you put into the AI product, but you also have to worry about hallucination. There are even concepts like temperature that I hadn't heard of until recently, where I
Oh
guess
yeah.
the AI is on a scale of a 0 to a 1, and then the 1 is the temperature where it's highly likely to hallucinate. The 0, it's not going to hallucinate, but it doesn't give it enough freedom to do its thing. And then I think Chat GPT, someone told me, is like a 0.7 with temperature. So just being aware of concepts like that, how that stuff works. Um, but I think soon, if not now, really you have to use some AI in order to remain competent. Make sure you don't miss stuff, when you're doing research. But one of the big concerns though is just how do you treat AI sort of like you're supervising staff. So if you ask a paralegal or a law clerk or an associate to do some research, how do you know what they've told you is accurate? So you probably need to ask the software those same kinds of questions. And some of the opinions that are now almost, it's funny to say they're almost old AI opinions, but they're really saying, is it worth the time to use the AI, considering you have to spend time to check behind the AI? So is it worth using it by the time you satisfy your lawyer obligations to make sure the AI stuff is working correctly? But I think lawyers shouldn't be afraid to use it. Just make sure you know how it works. And also, just with all kinds of vendors, the thing that I've been looking at recently is what should these vendor agreements say? What if a vendor, for example, is storing data for you and then they get a subpoena? So Clio, for example, is a company that I use and I really like. Again, intersection of practice management and ethics.
Mhm.
Clio, I think, is great. It's one of the few companies I think that actually works like it's supposed to. But in their terms, it says if they're consulted by law enforcement, law enforcement says give us files. If the law will allow it, Clio agrees in their terms and conditions to notify the lawyer and give the lawyer a chance to defend the against the subpoena. So,
Mhm.
can you use software, AI or otherwise, that doesn't have that provision in there? So there was a CRM I wanted to use the other day, and it aggravated me that didn't have the term. So I actually spoke to the CEO of the company, and very nice guy, but he just said, we can't change our terms just for you. And this, and he was saying, 99% of the time we wouldn't be able to contact you, the lawyer, anyway, on this subject. But anyway, I chose Clio Grow instead of the CRM that I was going to use, because Clio Grow again had that provision that said if they're contacted by law enforcement, and they're allowed to do so by law, they're going to contact me to give me a chance to defend my client's data, assert attorney-client privilege.
Wow. Well, that's um, using technology, then you might not be competent. And I think that that's true. So I'm going to do a subtle plug for ABA Tech Show, which will be in Chicago 2025. Great place to learn about all the different aspects of legal tech and sort of there's CLEs, it's like it is a trade show, and there's like the meetings. And we hung out there at ABA Tech Show not too long ago. Was that, I forgot what year that was. But
Yeah, I can't remember.
but no, that's really great. Well, I always ask guests, what's your superpower?
Oh gosh, superpower. Well, maybe a compliment I get a lot, hearing from not what I think, but what people tell me is non-judging. So I have some really extraordinary lawyers who call me and say they often feel judged. So they say they're able to call and tell me whatever problem they've got going on, and they don't feel judged, and it allows them to get the help they need. So
Oh,
I
that's
think that maybe is
good.
a good attribute for
Yeah.
an ethics lawyer.
It sounds like it. Sounds like it goes hand in hand. Okay, next question. What's your favorite board game or game?
I don't like a lot of games. I was an only child, and so my wife really doesn't like it. She likes to play all kinds of games. I don't like games because I grew up. I'm not really good at any because I never got to play them. But I think maybe Trivial Pursuit. So I like that one because it's about facts, right? So people ask you a question, you give an answer, and to me, a game that's just about this purely strategy, it's
Uh-huh.
not as interesting. So it's kind of just bringing So I'm spending time with somebody. So I don't want to be focused on what's the next, planning out some complex logic or strategy. Whereas if it's about Trivial Pursuit, to me, it's fun because, someone asks a question, you can talk about whatever the question is, that kind of thing. So, so I think it's pretty easy answer, Trivial Pursuit.
Okay, that sounds that's a fun one. And one thing I think would be really great is if there was like, and maybe this exists like for games, like to have a to let you know what percentages of luck and what is strategy, and like also like the fun factor of interacting with people, because then you could choose what's the right game for that environment and that group of people as well. I don't
That makes
like
good sense.
I don't like games that are just like so much luck. I think those are boring. I like a lot of strategy, but then you need a little component of luck and as well. Okay, well, thanks for humoring me with my two questions. So how could people find you if they want to enjoy a non-judgy conversation or just connect with you in some way?
Yeah, probably the best way, the place where I'm most active is LinkedIn. So they could just go to my LinkedIn profile, Craig Dobson. And I try to post Monday through Friday. Sometimes I slack off a little bit, but usually topics are either lawyer ethics or lawyer well-being. I go a little bit broad with that. Sometimes talk about things like green tea and other things, but other hobbies of mine. And then my website is dobson-law.com.
Awesome. So any final thoughts or something that we didn't cover or take away as we conclude today?
Oh, I think just thanks for having me. And I guess one maybe overall theme is, I think there's a book that talked about having good mental health is just being able to appreciate and deal with things as they are. So whether they're really good or really bad, just being able to accept things, pay attention and accept things as they are. And that's a really great part of practice management, looking at the numbers, that kind of thing, and then dealing with it. And then it's also a great thing with ethics, and also for really requires underlying well-being.
I definitely agree. It's all interconnected, and the balance is necessary for us to zealously represent our clients and be the best manager or owner or leader in our firm, as well as our best self for ourselves and in our family and those in our ecosystem. Well, thanks so much, Craig. I feel like we can always talk longer, but we'll just have to have you another day and tell us what's going on in the world of ethics. But I'm glad that you exist for us lawyers to have someone to call on and help guide us through what can be a very potentially scary experience, just like our clients who have us to hire us. But thanks so much for joining us today.
Thank you.
I really appreciate it. Thanks everyone for listening in. Your time engagement means the world to us. Please share this podcast with others. And if you enjoyed this episode and you want to continue the conversation, you can connect with us on the Facebook group, Power Up Your Practice. And exciting note, Power Up Your Practice, the book, is coming out in September 2024. And it's just a matter of days, minutes, and what have you. It'll be before you know it. So thanks for joining us, and see you next. Feeling overwhelmed by admin tasks? You're not alone. Many immigration lawyers are in the same boat. That's where Staffy comes in. Over 90 law firm owners just like you have turned to Staffy for help with legal, administrative, marketing, and client-facing work. Now, Staffy's mission: to help lawyers find balance while growing their firm. With bilingual virtual staff and full HR support, they take the hassle out of a team management and focus on what matters most, your clients and your practice. I've personally benefited from Staffy's support with 7 virtual assistants of my own across various areas of 2 of my businesses, including my law firm. Now, schedule a free initial consultation with Staffy. That's stafi.cc and use the code RUBY. That's RUBY for $500 off. Thank you for tuning in to the Power Up Your Practice Law Practice Management Podcast. I'm your host, Ruby Powers, and it's been a pleasure sharing this time with you. Join us next week for another episode where we'll continue to explore insightful strategies for success. Power Up Your Practice with us. See you next time.